Ontario's top court has upheld the sexual assault conviction of Canadian musician Jacob Hoggard. The former frontman for the band Hedley was sentenced to 5 years in jail after being found guilty in 2022 of sexually assaulting an Ottawa woman. Well, his lawyers appealed the ruling, saying that the trial judge erred by admitting evidence from a psychologist on the neurobiology of trauma. Well, the appeal court unanimously decided to dismiss the appeal, finding no substantial wrong or miscarriage of justice occurred at trial. And for more on this, we're joined by criminal defense lawyer Joseph Neuberger. So let's just start off with your reaction to the decision.
Well, the defense raised on appeal a number of substantial grounds of appeal, which included, as you've noted at the beginning, that a primary ground was the admission of evidence from Laurie Haskell, a clinical psychologist, about the neuroscience of responses to traumatic events. So that was a key aspect, and I found to be a very important ruling from the Court of Appeal. This was called essentially so that the trial judge could ensure that the jury would rule out certain myth-based reasoning about how a real victim of sexual assault would normally behave. And that has been something that we've understood for a good 20 years or more in criminal law, that there is no one way that a particular victim should or ought to behave or would behave. But in this case, there was a very, very limited scope that the trial judge allowed the evidence in and sort of articulated for the jury how they could use it. However, the jury came back with a number of questions that showed that there was confusion and the potential for the jury to misuse that evidence. So that was a very significant ground of appeal, and the Court of Appeal found, much to my delight, that this type of evidence is not necessary, can be very confusing to a jury, and this type of issue to be addressed can be addressed by the judge in an appropriate charge or an instruction to the jury. So that was one very important aspect to me.
Yeah, let's take that just one step further. The role of the psychologist actually testifying during this. What more can you say about that?
Yeah, so in a few high-profile cases, we've had this expert or similar experts testify to try and explain how a complainant or a victim of a sexual assault may experience the trauma, and therefore how it impacts their memory, their ability to recount, but more importantly, how they react. And the idea was to address discriminatory beliefs about how real victims of abuse behave. But again, it's unnecessary because we have known for 20 years or longer, and there's very, very strong case law rooting out these types of beliefs, that in fact, there is no way that one victim will behave or ought to behave. And so having a witness testify, an expert, it elevates that evidence to a level where a jury might be swayed because you have an expert in front of you, and then use that evidence in some way as confirming or doing an analysis backwards to say, this is what the expert says, therefore these factors which are exhibited by the complainants must be truthful of their experience. So it could be used in an impermissible way to in essence corroborate or support circumstantially the evidence of a complainant. And that's where it can cause very significant mischief. And the Court of Appeal strongly found that, in fact, there was this type of problem because the jury was asking questions that showed that they were having challenges understanding it and using it really on a basis to try and corroborate or understand better the complainant's evidence. So this ruling is very important to say this type of testimony is not necessary. And it's something that should not occur in these trials because there are very specific instructions that a judge can give a jury to properly allow them to assess this type of evidence.
Is there room for, or the possibility for, any type of appeal on any other grounds?
Yeah, so the defense raised a number of grounds. I mean, there's a lot that they've raised, including an imbalanced charge, admitting inadvertently other discreditable conduct because there are two complainants testifying. So I'm certain that the defense will then seek leave to appeal to the Supreme Court of Canada, and they'll address it. And the Court of Appeal used what we call the proviso to say that there is no miscarriage of justice here, even though this evidence was admitted. And I'm sure they will carefully review the judgment and try and suggest that, in fact, it did have that damaging effect on the outcome, and therefore they should have a right of appeal to the Supreme Court of Canada.
Okay. Criminal defense lawyer Joseph Newberg, thank you very much for your time this afternoon.